That looks actually kind of new, but it's apparently not. I guess I just didn't remember it. 170.15. Oh my God, this section is a fucking pain in the ass. Removal of action from one local criminal court to another. When the defendant is arrested by a cop for any offense besides a felony, allegedly committed in a city or town, has, owing to special circumstances and pursuant to law, not been brought before the local criminal court by reason of the situs of such offense has trial jurisdiction thereof, and therein stands charged with such information by simplified information, misdemeanor complaint, such court must arraign him on the accusory instrument. If he desires to enter a plea of guilty, they must permit him to do so and thereafter conduct the action to judgment. Otherwise, it must remit the action together with all pertinent documents to the correct trial jurisdiction court. So basically what all that mumbo jumbo says is that if you show up for whatever reason, you're brought to the wrong court, and you want to just plead guilty and like get the fuck out of there, they're required to let you do so as long as it's not a felony. 2. When a defendant is arrested by the cops for an offense other than a felony and is brought before the Superior Court judge sitting as a local criminal court for arraignment, such judge must, as a local criminal court, arraign the defendant upon the instrument. Such judge must then remit the action together with all pertinent documents to a criminal court having trial jurisdiction. So basically they're saying that the only time that they don't have to accept a guilty plea at the arraignment is if it's a Superior Court judge sitting as a local criminal court for arraignment. The latter court must then conduct the action to judgment. 3. At any time within the period provided by 255.20, what the fuck is that? 255. If I don't find it like right away, I'm not going to even look at it. Of course, I'm not going to mind. 250. Nope, it's going to be something really tiny and annoying. 255.20 is pretrial motions procedure. Okay. At any time, all right, so that's 45 days. So at any time, I guess within 45 days, when the defendant is arraigned upon all those same instruments, in a city court, town court, or village court, a judge of the county court in which city court, town court, or village court is located may, upon motion of either party, order the action be transferred from the in which the matter is pending to another designated local criminal court of the county upon the ground that disposition thereof within a reasonable time from which removal is sought is unlikely owing to A, death, disability, or other incapacity or disqualification of all the judges of such court, or B, inability of such court to form a jury in a case where the defendant is entitled to and is requested a jury trial. So obviously, in 170.15 sub 3, they are not talking about like Westchester or Nassau or something like that. They are talking about like Wyoming County upstate, something like that, where there's like one justice and, you know, he's on vacation for like, or he's, you know, or she's on maternity leave or something. And it's going to be a really long time before they get their trial. And there's like 25 people living in town, so they can't form a jury. But if there was going to be a question, if I was going to ask a question on this, I might ask about who would have to do it. And it would have to be a judge of the county court in the county where the town, village, or city court is located. And also, it can't be like sua sponte. It has to be upon motion of the defendant or the people. Anyway, now we go to 4. Notwithstanding any provisions of this section to the contrary, in any county outside New York City, upon or after arraignment of the defendant on an simplified information, PI, or misdemeanor complaint pending in an LCC, such court may, upon motion of defendant with consent of DA, order that the action be removed from the court in which the matter is pending to another LCC designated a drug court by the fucking chief administrator, and such drug court may then conduct such action to judgment or the final disposition. Provided, however, that an order of removal under this subdivision shall not take effect until 5 days after the date the order is issued, unless prior to the effective date the drug court notifies the transferring court that A, it will not accept the action, in which event the order shall not take effect, or B, it will accept the action on a date prior, in which event the order shall take effect upon such prior date. Now, this is how I should have done